Assalamu alaikum. My name is Atiq Ahmed. I am the student of political science. It's my first video on my YouTube channel, so hope you all will find it informative. It's all about, the theme of this video is the petition, as you all know, which was filed by South Africa against the Israel in the International Court of Justice. So if we talk about that specific petitions, it consists of 84 pages. Many scholars considering it's a very densely and heavyweight charge sheet prepared by South Africa against Israel. So according to the South African authorities, Israel is quote-unquote indulged in the genocidal activity against the Palestinian civilian. So that's why they approached to the International Court of Justice, which was established in 1946 for the purpose of to solve disputes between states. So in this regard, they approached to the International Court of Justice to end the Israeli aggressions and brutality in their genocidal act against the innocent civilian of Palestine. So before we indulged in the very core of this crisis, as you all know, the retaliation of Israel against the Palestinian after October 7 attack, which was conducted by the Hamas. Before that, we should understand certain basics. For instance, what is International Court of Justice? So as I mentioned earlier, International Court of Justice, it's the legal organ or the legal body or the judicial body of the United Nations. It was established back in 1946. The purpose of this court is simply to solve the disputes or skirmishes between states. However, according to its statute, which operate the International Court of Justice, its Article 59, there is no binding force of its decisions. However, its decisions, the decision of International Court of Justice is legally binding. It's legally binding, but technically speaking, there is no as such external organized force which implement the decision of International Court of Justice. In this technical point, it's committed or accepted by the statute itself in its Article 59, as I mentioned earlier, that there is no binding force of this decision. So we cannot expect something like a game changing from the verdict if it came in the favor of innocent Palestinian. However, we cannot ignore its symbolic impact. So the petition, as I mentioned earlier, it's filed by South Africa against Israel, which is related to the provision of genocide. According to the South African authorities, especially as their president Cyril Ramaphosa mentioned that Israel is quote-unquote indulging in the genocidal activities or acts, which is the violation of the provisions and obligations of the UN Convention on the Prevention of Genocide 1948. So that's why they approached to the International Court of Justice to make the Israeli authorities accountable and to stop and to bring any sign of relief to the poor Palestinian people. So it is also very interesting that why South Africa? Why not someone else? Why not the so-called leader of Muslim Ummah? Why not that? Why not they approach to the International Court of Justice? For instance, why not Turkey? Why not Saudi Arabia? Why South Africa? It's a very technical, I would say, question in this regard. That why they approach to the International Court of Justice. It's a country of 80% people are practicing or believe in Christianity. So why they just approached to the International Court of Justice to raise the Palestinian cause? So there is two school of thought in this regard. So according to one school of thought, they argue that the current party, the ruling party of South Africa, the ANC, the African National Congress, which is headed by the Cyril Ramaphosa, the incumbent president of South Africa. So according to this school of thought, the South Africa, or the current president Cyril Ramaphosa, approach to the International Court of Justice simply for political gain. So this is what we can say an extreme first school of thought. On the other hand, there are some pro South African voices in this regard. They just negate the first school of thought. According to this school of thought, they argue that no, there is no as such political objective or political gain to portray itself as the as a anti-apartheid. So simply this school of thought, the second school of thought, which as I mentioned earlier is a little bit pro-African or pro-South African. So according to this school of thought, no, Cyril Ramaphosa, the current president of South Africa, or beside the president, the whole African or the South African authorities, they filed the petition just for the sake of such brutalities they experienced in the past. Basically, they are just referring to the apartheid regime, the state-sponsored violence against South African in the past. They are just referring to that. So what I'm trying to say, as I mentioned earlier, that it's very interesting. There are two schools of thought. One is mentioning that the current South African authorities is doing such thing, taking such steps and trying to make Israel accountable for its brutality of Palestine just for political gain. However, the second school of thought, as I mentioned earlier, it's a little bit pro South African, and according to them, no, such acts as nowadays the Palestinian people as they are experiencing. So South African also experienced such brutalities in the past, such apartheid regime, such state-sponsored violence. So on the behalf of that, keeping their history into consideration, the current presidents are the administrative authorities. They just initiate such a move in the International Court of Justice to stop the Middle East crisis. However, it's it's a matter of debates that whether there is really any genuinity in the current administration of Cyril Ramaphosa, or they are just taking certain steps for political gain, or just to portray itself as a voice of anti-apartheid. However, it's a matter of debate. So if we talk about the global reactions to these petitions, so many countries, more than 57 countries endorsed these petitions, this initiative, and they are in favor to term the current acts, or the acts of Israel against Palestinian is quote unquote genocide, including Pakistan. So more than 57 countries endorsed and are appreciated, on the other way, appreciated the stance of South Africa. So it's a very public support to the initiative of South Africa. Its petitions filed in International Court of Justice against the Zionist regime, which is a matter of great importance. So the main thing is, beside this, as I mentioned earlier, we should also differentiate the ICJ from ICC. ICC stands for International Criminal Court, which is also based in Hague, the capital of Netherlands, and ICJ, the International Court of Justice, is also based in Hague, the capital of Netherlands. So what I'm trying to say is to differentiate the ICC from ICJ. Many people also use certain terminologies interchangeably, or mistakenly, or unintentionally, whatever. But it's a matter of importance that we should also differentiate certain terminologies. ICC stands for International Criminal Court. It's dealing with the individual crimes. It's many of you already know. It's in the previous year, in 2023, ICC issued its arrest warrant of Russian President Vladimir Putin on its aggression against the Ukrainian people. So ICC, it's responsible for the individual crimes. However, on the other hand, the International Court of justice, as I mentioned earlier, is the judicial organ of the United Nations. So it's responsible to mitigate or to solve dispute between states. So there is a very basic difference between ICC and ICJ. One is looking for the individual crimes. On the other hand, the ICJ, which stands for International Court of Justice, is looking for the state crimes. So what should we expect from this petition? What should we expect from this initiative of South Africa against Israel? Well, it's a matter of debate that can it stop the Israeli brutality or its assertiveness against Palestinian. As I mentioned earlier, that according to the Article 59 of the Statute of International Court of Justice, it cannot have binding force. However, the decision of International Court of Justice is legally binding. Let me repeat it again, legally binding, but there is no as such external organized authority which enforce the decision of International Court of Justice in any matter. So, according to its Article 59 of the Statute of International Court of Justice, there is no as such binding force. However, it's depend on the state will in with respect to certain crises. So it's solely depend or it's solely the discretion of a state that whether they are obeying the order of ICJ or not. However, its decision is still legally binding. There is a technical difference between legally binding and binding force. So hope you people understand it. However, besides to some extent pessimism, as I mentioned earlier, that there is no as such legal binding force of the ICJ, there is a huge impact and it possesses a great impact. For instance, the symbolic impact as well as many countries as we are experiencing, they are severing the ties with Israel against its brutality. For instance, the government of Recep Tayyip Erdogan, based in Turkey, they sever ties with the with the Israel. And many other countries, for instance, Bolivia, they regard their envoy to the Israel. So there is no as such external enforcing authority to implement the decision of International Court of Justice. However, its decision and its verdict still has great say in shaping the international relations. If someone, in this case the Israel, let's suppose if the decision came against Israel and the Israeli authority denied to oblige the decision and they just denied to obey the decision of International Court of Justice, so obviously the perceptions of many countries, especially which are really associated, are very near to the Palestinian cause, are something to the legal principle. Obviously, they will divert it or they will shift their loyalty. If we talk about the viewpoint of Israel, so according to them, we are not committing any act of genocide. We are simply depending our people, depending our infrastructures, and so on and so forth. Simply, they are referring to the Article 51 of the UN Charter, which is related to the self-defense. However, many scholars or many legal practitioners are not buying their narrative because there are certain technicalities in these provisions of Article 51 of the UN Charter, which is related to the right to self-defense. Article 51 provides to a state the right to self-defend, to defend its people, to defend its infrastructures, and so on and so forth, as I mentioned earlier. But this case is not a normal. In this case, Israel is, many of you know, it's an occupied power since its inceptions back in 1948. So, in this case, no one state possesses the right to self-defense. If an attack arises from the occupied land, mean from the Gaza, if we take just specifically take the example of the current crisis, if an attack arises from the occupied land on an occupied power, in this case, everyone know Israel is an occupied power, as I mentioned earlier from the very beginning. So if an attack arises from the occupied land, mean from the Gaza, so in this case Israel did not possess the right to defend itself. So in this case, Article 51 of the UN Charter cannot be activated, and it cannot be manipulated to defend or to shield its atrocities against Palestinian. So Article 51 in this case cannot justify the brutality and the assertive approach of Israel. So in this case, their response does not make any sense. It's the misinterpretation of Article 51 of the UN Charter. If we conclude this session, it is very important that the global power as well as the regional power take this crisis with their utmost. They take it serious before it's too late. Because since October 7, more than 23,000 civilians were killed, more than 1.9 million people were forcibly displaced, and more than hundreds of thousands of civilian infrastructures were also destroyed. So these all are is a clear-cut genocidal acts. It's clear-cut because it is beyond the scope of the definition of genocide mentioned in the UN Convention of the Prevention and Prohibition of Genocide 1948. So the global power as well as the regional power, especially the governing authority, the UN Security Council, must take this with their utmost seriousness, and they must adopt unequivocally, unanimously a ceasefire which can bring any sign of relief to the innocent Palestinian, as well as to stop the atrocities and the brutality of the Israel against civilian. Thank you so much for watching. Thank you so much.